Good morning to all of you. As traditional, I request all to observe silent prayers in our own ways before we start the proceedings. Amen. My Lord, the Honorable Chief Justice of the Gambia, Ashanbi Jallo CRG, are present, the Attorney General and Minister of Justice or his representative, magistrates here present, representative of the USAID, U.S. Embassy in the Gambia, consultant AB&Co law firm represented by Senior Counsel Mrs. Ann Bensouda, representative of the American Bar Association, the President and members of the Gambia Bar Association and Gambia Law Society here present, senior judiciary staff here present, members of the press, distinguished ladies and gentlemen, all protocols duly and respectfully observed. My Lord, with the support of USAID, U.S. Embassy in the Gambia through the American Bar Association, the judiciary of the Gambia has engaged consultant AB&Co law firm under the stewardship of Senior Counsel Ann Bensouda to revise the current rules of the High Court to stand the test of time. Judiciary of the Gambia has benefited greatly from the American Bar Association in different areas, and today's event is among host of projects extended to the judiciary. Undoubtedly, AB&Co law firm has done a tremendous work on revising the current rules of the High Court, which will serve as a working tool for the entire legal fraternity and beyond. Against this background, it is imperative for all of us to do our utmost best to review and evaluate and to review and validate the draft rules, as it will serve the current generation and the generation yet unborn, of course, subject to further review as time dictates. At the end of the 3 days deliberation, it is hoped that the validated rules of the High Court will be used purposefully. My Lord, without much ado, I now invite the Chairperson of the Rule Committee, my Lady Honorable Justice Jawara, to give us an overview of the whole process of the revision. My Lady.
Thank you, Honorable Judicial Secretary. Good morning, my Lord, the Honorable Chief Justice, my ladies and my lords of the Superior Courts. My Lord, kindly permit me to stand on the existing protocols. It is a great pleasure and honor for me to be part of this August session and to welcome you all to this high-level 3 days validation workshop on the draft rules, on the draft High Court rules. This historical milestone is anchored on the Strategic Plan 2021-2025 of the Judiciary of the Gambia. One of its main strategic objectives is to review all judicature acts and rules to reduce undue technicalities and bottlenecks. The implementation of this specific objective of the strategic plan justice delivery system. The significance of this strategic objective was recognized and appreciated by the American Bar Association, and as a consequence of which the American Bar Association did not hesitate to support the judiciary in this venture under its Rule of Law Initiative project by appointing the consultant, Ami Bensouda & Co., to review and revise the High Court rules. The appointment of the consultant was followed by a successful 2 days conference held in February 2023. The conference involved all the relevant stakeholders, in which participants considered some of the key provisions of the rules, identified the challenges, and made comprehensive recommendations for reforms. Coming on the heels of that conference was the consultant's submission of its first work document captioned Review of High Court Rules Overview of Proposed Changes. This was followed by another one-day stakeholders forum held in May 2023. The forum availed stakeholders the opportunity to consider the consultant's proposed reforms of the High Court rules. The comments and suggestions by the stakeholders on the proposed changes is the basis of the draft rules we will be validating today. My lords and ladies, distinguished participants, we all acknowledge that there are general and critical challenges to some of our rules of court including lacunas in some critical procedural law, such as judicial review procedure, commercial litigation, and human rights, hence the call from various quarters for the reform of these rules. The draft High Court rules seek to revolutionize the entire existing rules by repealing same and ushering in some new changes that address the procedural lacunas we have been grappling with, as well as ushering in new rules that address the changing legal landscape. Our task today, therefore, is to deliberate on all aspects of the draft rules, but paying great attention to some of the key and major provisions of the rules that reflect the several major changes, such as the introduction of the commercial code rules, enforcement of fundamental and human rights rules, intellectual property rules, and alternative dispute resolution process. Another major highlight in the draft rules is the provision of virtual hearing. This specific provision embraces the use of technology to conduct virtual trials and undoubtedly enhance speedy trials, as well as reduce cost for litigants and witnesses out of the jurisdiction. I anticipate that special attention will be dedicated to these very new proposed reforms, with emphasis on the operational effectiveness and potential challenges. My lords and my ladies, distinguished participants, at this juncture, I would like to express our special gratitude and deep sense of appreciation to my Lord the Honorable Chief Justice for his exemplary leadership and spearheading the introduction of a well-defined strategic plan. Our special gratitude is also extended to the American Bar Association for sponsoring again this validation workshop. We also extend our gratitude particularly to the moderators of sessions, the consultant, distinguished participants, and the management and staff of the judiciary. I once again welcome you all to this validation workshop and wish all of us a very fruitful and successful engagement. Thank you.
Thank you very much, my Lady Honorable Justice Jawara JCA. I now invite the representative of USAID, U.S. Embassy in the Gambia, to make a remark.
Honorable Chief Justice Hassan B. Jallow, good morning, and I would like to also stand on existing protocols. I'm excited to be part of this opening session of the validation of the High Court rules. It is an important and historic event, and it is an honor to be part of it. I would like to highlight that today's event reflects the steadfast commitment of the U.S. government through the Agency for International Development, USAID, to support the Gambia to build strong foundation as the country nurtures its budding democracy. Promoting Rights and Justice, which is the $7.9 million project implemented by Freedom House and the American Bar Association Rule of Law Initiative, also called ABA-ROLI, was one of USAID's first investments in the Gambia after USAID closed operations during the dictatorships. And this reflects the U.S. government's commitment to supporting the Gambia's democratic development. USAID, through PRJ, has been strengthening the Gambia's judiciary through reforms and the provision of judicial officers and court administrators with essential tools, knowledge, and training. Key initiatives include the introduction of the Case Management System, CMS, and Computer-Assisted Transcription System, CATS, a human resource management framework, and the revitalization of the Judicial Training Institute, including the development of an induction manual. The PRJ also supported the review of the Alternative Dispute Resolution, ADR rules, and providing court-connected mediation training for mediators and legal practitioners, along with the creation of an ADR code of conduct and manual. Ethics training to the Judiciary Communication Department, which is further strengthening the judiciary's capacity to be more transparent and accountable to its citizens. As part of its work to support the justice sector and therefore increasing access to justice in the Gambia, USAID PRJ has supported the judiciary to review and reinstate the rules of the High Court on the specialized divisions of the High Court. The draft High Court rules were developed to enhance the judiciary's ability to manage court processes through modernized and streamlined systems. These rules aim to address the backlog of cases and reduce delays in case resolutions by assigning specific subject matters to each division. The review of the High Court rules is one of the many areas where USAID is partnering with the judiciary, as I mentioned. The transition towards a more structured and efficient court process aligns with the broader goals of enhancing the judiciary's effectiveness and ensuring that justice is delivered more quickly, fairly, and equitably to all citizens. On behalf of USAID, I would like to commend the judiciary for the leadership role they have taken, spearheading the process and ensuring the involvement of all stakeholders. Throughout the process, various stakeholders from the justice sector shared their comments and observations on specific amendments of the High Court rules. We are proud of the work that USAID and the judiciary have accomplished together on this activity, as well as many others I mentioned earlier. I would like to acknowledge the great work of our implementing partner, ABA Rowley and Freedom House, for ensuring that this review took place. I have the belief that with the great work done by both the judiciary and PRJ, and with your active participation throughout the process, and today at this validation workshop, the new High Court rules would significantly improve case management in the High Courts of the Gambia. I wish you a successful validation, and thank you for your attention.
Thank you very much, Madam Representative of USAID, U.S. Embassy, the Gambia. I now invite the representative of the American Bar Association to make a remark.
Thank you. My Lord Chief Justice, Honorable Hassan B. Jallow, allow me to stand on the protocol that has already been ably established. On behalf of the American Bar Association Rule of Law Initiative, Abaroli, and also on my own behalf, I would like to take this opportunity to welcome you all to the validation of the High Court Civil Procedure Rules 2024. Briefly about the American Bar Association. ABA Rowley is a non-profit organization that implements the rule of law, justice reform, and human rights. ABA has been working for over 25 years in over 100 countries to promote the rule of law, advance human rights, strengthen judicial institutions, support legal professionals, and advance the understanding of law and rights of the citizens by the public. ABA Rowley works by establishing partnerships with a wide range of actors, including justice sector institutions, civil society, aid organizations, lawyers, among others. It is therefore in this regard that ABA Rowley, with support from USAID under the Rights and Justice Activity Program, is partnering with the judiciary to improve the institutional capabilities within the justice sector, thereby ensuring that Gambian justice sector institutions have modern and streamlined systems to manage court processes. Allow me to thank USAID for their support in helping us to realize this goal, as well as also the Honorable Chief Justice for allowing us to collaborate with the judiciary. We have been able to do very many activities with the support of the judiciary and also with the support of USAID. And among those activities are the CMS system that has already been mentioned, the CAS system, as well as also developing a human resource framework for the judiciary. The question then comes in, why the High Court rules? In my opinion, the High Court rules form the cornerstone of the judicial process, providing a framework within which justice is administered efficiently, fairly, and transparently. The High Court rules intend, therefore, to provide clarity, consistency, and predictability, ensuring that justice is not only done, but is also seen to be done. It is therefore of utmost importance that these rules are both practical and aligned with the demands of the modern justice practice. The validation workshop therefore marks a critical stage in the development process of the High Court rules. For 3 days, you will come together to rigorously examine, refine, endorse these proposed rules. Your feedback will ensure that these rules are not only legally sound, but also pragmatic and implementable in the real modern world. Thus, your presence here today to validate the rules underscores our shared commitment to ensuring that the judiciary in the Gambia remains effective, efficient, and responsive to the evolving needs of justice. As we validate these rules, it is crucial to recognize the ever-evolving nature of the legal landscape, shaped by technological advancements, expanding access to justice initiatives, and the increasing complexities of cases. These factors require us to remain agile and adaptable in our approach. I trust that these rules will effectively reflect and accommodate the ongoing transformation of the technological environment that we are currently in. Let us seize the validation process as an opportunity to future-proof the High Court rules, ensuring that they not only remain relevant in addressing the current challenges, but they are also resilient in the face of emerging issues in the future. As you engage in your discussions, I wish you fruitful deliberations. With your vast experience and profound understanding of the judicial practice, you offer an invaluable insight that is essential in ensuring that
Thank you very much, Madam Representative of the American Bar Association. I now invite His Lordship, the Honorable Chief Justice Hassan B. Jallow, to make an opening statement.
Honorable judges of the Superior Courts, Your Worships, President and members of the Bar, our distinguished guests, the new head of the ABA, Madam Sandra Oriema, and the representative of the USAID. Good morning to all of you, and welcome all to this forum, but particularly welcome to Madam Sandra, who's just joined us as the new head of the ABA in the Gambia. We say Karibu. Karibu tena. You're all welcome to this forum. As has been indicated, it's taking place against the backdrop of the implementation of the strategic plan, one of whose objectives is to make sure that appropriate, adequate, relevant rules are in place for the procedures, to regulate the procedures of the court and the governance of the courts in order to help us attain our mission statement of providing quality justice in a timely manner. As lawyers, of course, we know how crucial, how critical justice. Much depends on what the rules say and how they are operated. The ABA and the USAID, of course, have been very, very strong partners for the judiciary, and beyond that, indeed, for the whole country, in reestablishing, consolidating, and strengthening the rule of law in our country. They have been instrumental in the implementation of the strategic plan and have supported various initiatives. And we thank them very much for their support and continue to look forward to their cooperation in this respect. Our rules of practice and procedure for the High Court, of course, date back to 1928 when they were introduced as the rules of the Supreme Court. That's just 4 years short of a century. It's 4 years short of a century, so they've served us for a long time, and they have served us well in many respects too. But nonetheless, they need to be reviewed. Life and the law are both characterized by change and by continuity. some things remain, some things need to be changed. And so we need to review them in that context. I'm sure even as we validate the new rules, we will discover that we found some things in the old ones which are useful for us to keep, but we also realize that we need to respond to new challenges, new demands, and seize new opportunities which have arisen. And amongst them, for instance, the growing demand for quality, expeditious justice, a growing demand for avoiding undue technicalities and focusing on delivery of justice, the need for us to harness technology in order to make our systems much more efficient, for us to move from our old ways of working, which are very, very manual-based, to adopt new technologies to improve our efficiency. The need to respond to the need to respond, for instance, to the demand for greater specialization in the administration of justice, the creation of specialized courts, such as the commercial courts, among others, and overall, the need really to enhance the speed with which justice is delivered. These have been the considerations behind the review, and I am confident that at the end of the day, we would respond with the adoption of a set of rules which respond to these particular demands. I'd like to thank very much our consultants, AB and Company, under the leadership of Madam Bensouda, who have again come forward to help the judiciary in the implementation of its strategic plan. They have helped us in other aspects before, and we commend them not just for their assistance, but also for producing what is quite a very good draft for us to look into. So the Rules Committee, which will eventually promulgate these rules, as a member, I look forward to receiving the adopted set of rules, and then we can move forward from there. But even as we, I think, consider the details of the rules, we need to give some consideration as to how to move forward after their adoption. It is not easy to bring into force a whole set of new rules immediately. It requires time. It requires time for specific stakeholders to be familiarized with the content of the rules. And here, for instance, not just judges. The judges need time to look at the new rules, to familiarize themselves with it. The lawyers need to do that. The registry in the judiciary, which very much operates the rules, will need time for implementation. And so I envisage after the adoption of these rules that there will be time and an opportunity, together with our partners, the AB and the USAID, to organize specific meetings targeting those specific stakeholders for them to have sessions on the rules in order to enhance their familiarity with the new rules, so that once they come into operation, we can avoid many of the potential. Once again, welcome very much to the forum, and we look forward to successful deliberations, and at the end of the day, the validation of what clearly, I think, in my view, provides us with a framework for achieving our mission statement of ensuring that quality justice is delivered efficiently and expeditiously. I thank you very much for your attention.
Thank you very much, my Lord the Honorable Chief Justice, for that opening statement. I think it is now convenient to go for tea break, and I was made to understand the tea is going to be served on the first floor. And the rest of the proceedings are going to be moderated by justices of the Supreme Court when they come back from the tea break. The tea break will be preceded by the group photo outside. And we are back here by 10 o'clock. All of us should be back by 10 o'clock to start the 10:30.